strike, and they've been on strike since the middle of the week. And so in the last 2 or 3 days, the courts haven't worked. It is a major issue because without them, judges cannot sit, and so your matters cannot be adjudicated upon or heard. That has serious implications for justice delivery in the country. What is their concern? They are complaining about conditions of service generally. Their salaries, they say, have not been reviewed in the last 2 years. And indeed, there's an arrangement they've had with government which suggests that every 2 years their salaries are reviewed. And given the fact that Ghana is in some economic difficulties, inflation is high, etc., they say that they are struggling, and so they need government to speak on their matter. By some arrangement, their salaries and matters concerning their conditions of service must be approved by the president himself by the dictates of Article 149 and Article 158. And they say that attempts to get this approval has been very slow, it's not been forthcoming, and it appears the only language that government understands is strike, and that is what they have done. Since then, justice delivery is ground to a halt. There's been some attempts to call them for meetings, and they're also not happy with the National Labour Commission. They feel the National Labour Commission is in bed with government and trying to hold brief for government when government itself is not ready to come around the table. We'll look at all of this. Do they even care at all about the implications of their strike on the innocent public? There are people who are in custody who want to go to court for bail, and because the courts are not sitting, they will have to keep being in custody, which will be in violation of their rights. Mind you, they cannot be in custody beyond 48 hours without the order of the court. What happens to all of this? And we will find out more. So they will be on the program today. Still talking about the judicial system of Ghana. Yesterday, incoming Chief Justice or nominated Chief Justice Gertrude Tokonu appeared before the appointments committee. People think she discharged herself quite creditably well, but the minority appears to have an issue. They want the reasons in the recent Judicial judgment panel the Honorable Justice of the Supreme Court, Tokonu, was part of, to be available before they can pass, judgment on their on the vetting, and they want the reasons available so they can quiz her on some of the things that the court or the conclusions the court arrived at. The chairman of the committee, JuSAC, says is having none of that. There will be no part 2 of the vetting. And so, as we speak, Tokonu's approval will be made on majority basis. It's not by consensus, which appears that it will have to go to the floor of Parliament. It will have to be debated, and it may come to a vote. And if you understand the numbers in Parliament, all of that could play for or against it. The question is, do we really need that? Why couldn't we defer the vetting until after 7th June, when the Supreme Court has said the decision or the reasons for the decision will be ready? Parliament resumes on 6th June, and Supreme Court says it's making the reasons available on 7th June. Was there a reason why Parliament or the Appointments Committee couldn't wait until after 7th June to do the vetting? We will look at all of that. Also, in the second part of the program, we will seek to shed some light on Ghana's deal with the IMF. What is in for the financial sector, the public generally? It's been said that the conditionalities listed in there are quite harsh. What happens? Utility prices or utility tariffs will be adjusted every quarter, and a whole lot of things. However, there appears to be some good news in there for LEAP beneficiaries and other social protection programs. We'll look at all of that and then see what Ghana stands to gain. This is the big issue. The show, as always, is interactive. You can join us via our WhatsApp line, 020-444-7033, 020-444-7033. Also on 0549-986-996. My name is Selom Adunu. I'll take a short break. I'll return, introduce my guests, provide some updates, and we'll get a discussion underway. Once again, you're welcome. You're welcome back to The Big Issue on 97.3 City FM. My name is Salom Adonu. Two major issues on the table: the judicial service strike and what that means for justice delivery generally in the country, and also still with the justice delivery system. Chief Justice Kwesi Yeboah is gone. He is on retirement. He retired on May 24, and then a new nomination has been made. Nomination was made in April. Justice Stockholm was vetted yesterday, but minority appears to have some issues. We'll delve into all of that. Second part of the program will deal with the IMF and what that means for the financial sector and the economy generally. So that is what we're looking at. But let me just provide you some updates. And so the judiciary this week has been in the limelight for a number of reasons. The nationwide industrial action declared by the Judicial Service Staff Association of Ghana, JuSAC, has brought justice delivery to a halt across the country. Members of the association have laid down their tools over non-approval of their new and improved salary structure for the period between 2023 January and then 2024 December. When City News visited some facilities across the country on Thursday and Friday, including the court complex in Accra, the courts were shut. There is more in the following report.
According to Article 149 and 158 Clause 2 of the 1992 Constitution, it is the responsibility of the President, upon the advice of the Judicial Council and in consultation with the Public Services Commission, to determine the salaries of judicial service staff. Traditionally, these emoluments are reviewed every 2 years. However, JuSAC claims that the last review took place in January 2021 and insists that another review should have been conducted since then. After several unsuccessful attempts to obtain government's approval for the new salary structure, JuSAC declared a strike on January 24, 2023. The strike has had a significant impact on the legal system, with court proceedings coming to a halt across the country. As a result, courtrooms remain closed, leaving individuals seeking legal services in a state of uncertainty. The Judicial Service has appealed to JuSAC to suspend its action, but the General Secretary of the Association, Abdullah Yakubu, says the group cannot call off the strike without anything concrete on the table.
We respect the call that they are making, all right. We understand the interventions that they have done, and we are very much appreciative of the work that management, the acting Chief Justice and his management has been doing and have done for us. However, at this moment, we don't have anything on the table, and when you don't have anything on the table, you cannot call off the strike. Otherwise, the whole thing becomes meaningless. At least if we have some pre-meeting discussion and commitments being put on paper and signed by all the parties, given a clear roadmap as to how our demands are going to be met within a certain time frame, then it becomes convincing and enough commitment for us to think of not calling off the strike, but possibly suspending the strike, hoping that within the window given, we can resolve the matter and we'll now call it off completely, or if it is not resolved, then it will continue.
A visit to various courts in Accra, including Kaneshie District Court 1 and 2, the Law Complex and the Circuit Court, revealed deserted premises with only a few frustrated clients who were unaware of the ongoing strike.
I came to pick my land document at a registrar's office, actually. I'm here, they say they are in the strike, so I don't know how to do. And then I don't even hear anything about that. So I just arrive and then know that they are in the strike. I'm coming from Kasua of Angkor.
That's quite far.
Yes. So I don't know. It affected me because I'm using the document for my papers. So I have to take it. And I don't know the day that it will be resumed.
I'm here today to find out exactly what's going on, because actually we have cases, to be heard today, but unfortunately, due to this strike action, administration of justice had come to a halt.
JuSAC acknowledges the difficulties faced by court clients, but refuses to take responsibility for the impasse. Abdullah Yakubu, the General Secretary of JuSAC, asserts that the government could have taken more proactive measures to prevent the current situation. JuSAC insists that concrete action must be taken by the government before they consider suspending the strike.
In fact, we are so sorry for the clients who turn up to the court and only to be disappointed. If they had listened to City FM Eyewitness News on the day we declared a strike, they wouldn't have wasted their time to come to court. However, the situation we found ourselves in was avoidable if the government had paid heed to the warning signals that we give. If the government had respected the directives of the Labour Commission to organize the meetings within the 2 weeks window that was given to us, so that we could have resolved that issue from that period. If the government decide not to address those issues within that period, then it appears as if government wasn't paying attention to the repercussions that our strike will have when it is finally declared. And we are now at where we are. The blame should not be placed on the doorsteps of JuSAC members who are struggling and suffering because of the meager incomes that they earn. It should be directed to government to tell us why they allow us to pass through all this process and get to where we are now without our demands still not met.
Today marks day 2 of the strike by the Judicial Service Staff Association of Ghana. Our assessment of the court premises this morning reveal a similar situation from yesterday. Empty court premises, empty courtrooms. Work has actually come to a standstill. The Judicial Service Management appealed in a statement to JuSAC to return to work while negotiations continue, but that appeal has actually fallen on deaf ears. The strike continues. My name is Charles Osukumi. I've been reporting for City News.
Arriving at the court complex in Idum, a police vehicle transported 5 clients of lawyer William Ehiadome, who are currently standing trial for a murder case. Their hopeful anticipation for a ruling on Thursday was dashed as they were unable to access the court and were subsequently returned to police custody. Their counsel expressed deep disappointment.
It's a serious case. Some people, I would say, are wrongly accused of murder. And today is the ruling. And we are here and the premises are not open. They've been in cells for more than 1 month. And they are going back to cells because they cannot open the premises for the court to sit. Even though we know that they are innocent. The ruling is what can free them for them to go home to their children.
You look disappointed.
So disappointed. Lawyers are not supposed to put into their lives some emotions, but it's heart-rending to have your client going back to prison when probably the ruling would have favored your client this morning.
The situation was no different at the KMA and ASCO courts, where court users faced similar setbacks.
I'm very upset because since Monday I had a case and the judge wasn't available that day, and now today I'm told that there's a strike. And it's sad because these are, urgent cases.
Before we send it to the Kofanoche, before they can release the body. But as of now, we are yet to go back and find out.
When you came, what did they tell you?
They say they are on strike. Even yesterday, I saw it on television. So they are on strike. So you have to go back and see the next line of action.
What will you do now? During the news team's visit to the ASCO court complex, we encountered another private legal practitioner who had come to follow up on a case.
Well, my client is disappointed. Of course, we were hoping to do some business today, but unfortunately, it can't happen. Yeah, so as I said, we have to wait. When the matter is resolved, then we'll know the way forward.
The lawyers and their clients are appealing to the government to address the concerns of the striking judicial staff.
Lawyers and their clients, as well as other individuals who are accessing the court premises within the Kumasi metropolis and in the Ashanti region, are only meeting empty premises, and they had no option than to go back home. Hafiz Tijani, City News, ASCO Court Complex, Ashanti region.
All right, so that is some reports from the Ashanti region, and earlier I saw the one from Greater Accra. Still with the judicial system, Chief Justice Justice Kwesi Enieboa on Wednesday, May 24, 2023, officially retired from active service. Justice Enieboa served for 21 years as a judge, 73 years as the head of the judiciary. Following his retirement, the Appointments Committee of Parliament yesterday vetted Chief Justice nominee Gertrude Eraba Tokonu. The Chief Justice nominee answers questions, including the Supreme Court's issuance of contempt summons to persons who denigrate the image of the Apex Court, issues of legal education, and the delay in the release of the written judgment of the Apex Court on the order of Parliament to expunge the name of Judge James Kwesi from its record. There is more in the following report.
The minority leader, Dr. Kezia Latoforsen, in his opening remarks at the vetting of the Chief Justice nominee, Justice Gertrude Tokonu, made it clear that the minority would not vote on the approval of the Chief Justice nominee until reasons behind the ruling of the Supreme Court on the Asin North MP, James Kwesi, in the dual citizenship case is made known.
We are of the view that we should be given opportunity to get a copy of the ruling so that we can be able to ask her questions based on her ruling. We are going to start the vetting, obviously, using the information that we have. But unfortunately, we cannot conclude on the matter until we have the ruling on the latest judgment for that she took part. So, the Chairman, I think it's pretty straightforward.
It is open for anybody whilst we are here to ask any question. Yeah. But please let it not appear that because a judgment of a court, not her judgment, the Supreme Court, you have not had a copy, it in any way precludes the Appointments Committee from concluding elsewhere. I don't think we should encourage that kind of nonsense.
The Judicial Service Staff Association of Ghana, JuSAC, on Wednesday embarked on a nationwide strike over what it says is the government's delay in reviewing its salaries and related allowances due to the industrial action courts across the country were locked. Speaking at the Appointments Committee during her vetting, the Chief Justice nominee, Justice Gertrude Tokonu, assured that the court would soon be opened due to ongoing discussions to resolve the matter.
The strike that was pronounced recently, to the best of my knowledge, and not just briefing, but personal knowledge, matters are under control. We've had meetings with them. We are one family, and I believe that very soon we will see the court doors open.
Can I, in respect of the strike which you have just made, what is the specific issue on which the Judicial Service staff have gone on strike?
It's about the review of salaries. There is a structure for the review of salaries on a biannual basis, and that process started. And staff, I think, are of the opinion that it's going too slowly, and this is why they've gone on strike. But the process is very much going on, and yesterday we were in meetings.
Has the judiciary defaulted on their part of that process?
I would say not at all, because it's not a process that's limited to the judiciary. It's a process that starts with proposals from the judiciary, goes to the Judicial Council, goes to the executive, Ministry of Finance is involved, the Office of the President is involved. So it's a cycle, and then they get back to the judiciary. It's a cycle, and as I said, the process is ongoing. I think their complaint was that it was going too slowly.
Justice Gertrude Tokonu also made it clear during her vetting that the issuing of contempt summons is to ensure that the Apex Court is not scandalized beyond boundaries, and this comes on the back of a summons that was issued to a lecturer of the University of Ghana, Dr. Kwesi White, for making a comment deemed as derogatory against the Supreme Court.
We have close to 400 courts. Within these 400 courts, we have 5 levels of courts. district courts, circuit courts, high courts, Court of Appeal, and Supreme Court. The Supreme Court is just one out of these 400 courts. And the Supreme Court is the ultimate voice of authority for the entire judicial stream. Now, if the Supreme Court is not alert and alive to its responsibility to ensuring that the justice systems are not denigrated beyond boundaries, those below us are likely to suffer much more than we. And I can say that this is not a recent trend. The issuing of contempt summons has always been a tool that has been used by courts to ensure that the dignity of the court is not scandalized.
Justice Gertrude Tokonu also denied assertions that the Supreme Court is biased when delivering rulings on political cases. She explained that the unanimous decision means that the ruling is based on law.
Whenever you encounter a unanimous decision, it tells you that the law is totally on the side of the position taken by the court. That every member of the court, in fidelity to their judicial oath, cannot take a different position. It tells you that that is what the law is. So the only response is to learn from what the law says. So it's not a matter of bias. It's a matter of the legal position.
She also advised the public to desist from giving out monies to intermediaries in a bid to influence judges, because most of these monies do not end up with judges.
The Judicial Service has more than 7,000 employees. Only 400 or so are part of the judiciary. Anyone who presents themselves as able to take money on behalf of a judge gives that perception. And very often, we as judges, including those of us with the reputation of being unbribable, find ourselves in that corner where people go out and present that they are going to give you money. And others believe it because they don't know it. So they don't know that you are unbribable. So there's a whole market, we call it judicial predators. There's a whole predatory group around our function. And that is something that we constantly try to address in our study of ethics, both for judges and for staff. So there are interventions. They just have to be deepened. And then for the community to understand, this is something I would really love to tell Ghanaians, that for every 10 people who tell you, give me money for a judge, you can be sure that 9 likely is going into that person's pocket and not to a judge. So please, don't give money to people to take to judges, because it's their own market.
Well, so you had CJ nominee Gertrude Tokonu appearing before the committee yesterday. And so we'll start off our discussion on that note. My guest this morning, Franklin Kujo, President Imani Africa, the Honorable Mahama Yariga, MP for Boku Central, Alexander Aban, private legal practitioner and former MP, Goma West, Kweku Pencil, Managing Partner of Pencil Law, Abdullahi Yakubu, General Secretary of JuSAC. Gentlemen, you're welcome to the program. So let me start off with you, Honorable Aban. So you followed the vetting of the Chief Justice nominee yesterday. What were your general impressions? Did she impress you? Were you satisfied with some of the answers she gave to some of the very topical and thorny issues of judicial independence, bribery and corruption in the sector, and all of that? What were your general impressions?
Thank you very much. Good morning to you, and good morning to our cherished viewers and listeners. It's been a long time since I appeared on BBC.
Yes.
And this is the first time I'm coming to this studio. Very beautiful.
Thank you.
I must commend you for good work done.
Thank you.
Having said that, let me now try to answer the question that you posed. I followed the vetting, but not, I didn't listen to the full length of it. But what I heard, what I saw, I think Justice Tokono discharged herself creditably. She did well. And yesterday there was a comment by one of the MPs, I think Obiamwa, Honorable Obiamwa, who said that many people are trying to claim her. As a Gumwa man.
You're also claiming her. Okay, of course.
Yes,
of
let
course.
me claim her.
Of course.
Because this information is not from any other person but from herself.
Yes.
That she's from Gumwa.
Yes.
So, my fellow Gumwa person, congratulations to you and welcome to the hot seat, I guess. But I think she did well. She tried very hard to answer all questions. You know, there are people who think that she was elusive in some areas, especially what would be her votes on some issues and all that. So long as she would remain a judge and the matter is likely to come before them, she does not need to express an opinion here. In that case, she her comments would have been prejudicial in case the matter finally travels to the Supreme Court as a court for them to determine. So it is for this reason that for those who think that she was elusive in some of the questions, they must understand. I was having a discussion with a friend and he said, oh, it's because you were a lawyer, that's why you are speaking this way. But others felt that there were certain questions that she should have given yes or no answer, especially this LGBT matter, when Honorable Ntim Fojo asked her about it. She found a very crafty way of answering it and avoiding jumping into the arena of conflict, because I'm sure that with all the controversies surrounding the passage of that bill, I would not be surprised at all if later we see that some people are going to the Supreme Court, for instance, to say that certain aspects of that law, that is, if it comes to being, okay, are unconstitutional. The Supreme Court would have to sit on it, and probably as the Chief Justice, she would have to empanel members of the judiciary to sit on it. She could also sit on it
herself.
And then people would say, oh, but during your vetting, you said this. And if you're going to empanel people...
You've already expressed a view.
Yes.
So your position
are
is
they not going to follow your position, being the Chief Justice? So I think she did well. I pray that the Parliament would give her the nod and then she can assume the duties of her office. Let me make a comment on what my friend Muhammad Ayaga said, and thankfully he's on this program.
Yeah, so we'll deal with that. So I'll come back to you
on
the aspect of the minority. Okay. So and the concerns they raised generally about the Judicial judgments, the unavailability of the reasons for which reason they are unable to approve her now. So we'll deal with that. Senior Pencil, what's your view really on some of the matters she talked about? So the matter about corruption and bribery in the judiciary came up. She also the view that normally, in fact, I think she said 9 out of 10 or 8 out of 10. 9 out of 10, people coming to you to say they wanted money or the judge needed money, give me money, I'll give it to the judge to rule in your favor. He said a lot of the times, or 9 out of 10 of the times, they were not true. And he said they were called judicial predators also, who would take money, but the money would never get to the judge, trying to say that the judges really are not corrupt. But we also saw what happened in Anna's video, where some judges were seen personally taking money, etc. How do you juxtapose a comment on judicial corruption against what we saw in the Anna's video, where justices were taking money and sometimes waiting for people at lorry stations to collect money and all of that.
That's a very interesting observation. But my take on this issue of judicial corruption is that more than 90% of the time, it's my view that it's a question of perception. It's perception. And I'm not too surprised people make those comments because, see, the generality of Ghanaians, I mean, we are who our society, or what our society is. We come from the society. There are all kinds of things that happen in this country, and therefore there's always a belief that everybody does the same thing. And I'll put it much more this way. You know, if you ever read Shakespeare, Julius Caesar, they say Caesar's wife must be above suspicion. So, however, the background of anyone, wherever you come from, the idea is that once you become a judge, then you are subject to new standards. And by so doing, you are to live above the ordinary days of reproach. And I'll put it this way. There's so much suspicion within the society that even judges are not supposed to have friends. Judges are not supposed to have friends as lawyers. Judges, and so there's a kind of culture that we have cultivated in this country, which is quite strange. Because every conversation with a judge outside the courtroom is interpreted and is read into all kinds of things. But let me tell you what, I've been in this business for quite some time, and I have come to the conclusion that the law will always be the law. Even if a judge, I'm not saying I know of any particular, first and foremost, bribery and corruption is a question of fact. In other words, if you know of a judge who has taken a bribe, name him, mention him. Our clients, they come and tell us all kinds of things. Half of it is fiction, stories. We know of clerks. In those days that judges write judgments, manually give it to the secretaries to type. When they've seen the judgment, they go around to the parties. They know the one who's going to win. And they go and they say, listen, the judge wants this and this and this. They already know the judgment. But, so there are many, many things that fuel this perception over the period. But let me make this point quite clear. That even when a judge takes bribe, the judge has to be on the right side of the law. In other words, you don't lose a case merely because a judge has taken a bribe. Because of the system of appeals that exists in the judiciary itself. So my general comment is that the issue of judges and bribes is more of a perception that Ghanaians have created. It is overblown beyond the reality.
You don't lose a case simply because the judge is taking bribes.
No.
Because of the appeals, system. But, litigation is expensive. If an ordinary person doesn't have a lot of money, thinks he has a good case, and maybe he has a good case, he goes through the court system, and something happens along the line, and judgment is, he doesn't get judgment. Of course, his remedy may lie in appeal, but that's also another expensive process.
Now, let me make the proper point. Okay. The proper point is that the facts before the court, the evidence before the court, the law that plays on these two is what takes a court to deliver a judgment. But then what really happens is that because somebody saw the judge speaking to the other person, he concludes that by reason of that fact, he lost the case. I'm saying there cannot simply be that. In other words, whatever takes place between a judge and somebody cannot be the real reason why the case. In other words, even the one who offered a bribe has a case before the court. In other words, that person would ordinarily, under normal circumstances, would still have won his case. So therefore, the whole idea that judgment is delivered according to who pays what or who knows what, in my view, is overblown. But please, that's not to say, as shown by the announced videos, that these things are not facts of life. But as a lawyer, I'm very careful, even when I'm dealing with my clients, that I don't fuel perceptions. I don't interpret things beyond what they really are. Because you go to court and your client say, the other lawyer came in and he went in to see the judge. And so what? So there are things that we ourselves have to put in place.
Yes, justice must be done, but it must also be seen to be done.
Not
only must it be done.
So
if I have a matter before a judge, and maybe I'm in the court waiting for the matter to be called, I got there earlier, but I see the other lawyer going to see the judge in chambers. I mean, and the matter, that lawyer has a matter before the judge. it fuels that perception, and rightly so.
It does so.
I'll be right in thinking that something may be going on, even though it may not be the case.
I agree with you. So we have developed acceptable behavior at the bar, at the bench, and all of these things are intended. So, like you said, the right and proper thing to do, if for any reason, even if I don't have a case before the judge, and I do it very regularly, and for some reason I need to talk to a judge, you call a fellow at a bar, you go in to listen into the conversation. A good judge will also ensure that he's got a clerk before you, because this conversation sometimes have to take place in chambers. And that's the proper thing to do. But like life is supposed to be, once in a while, there must be a slip. And that one slip is then interpreted in a way as to suggest that a particular judge or some judges are so corrupt. But my conclusion on this point is that the issue of corruption exists, but it is insignificant from my own experience. And that those single or those ones are the ones who possibly have given a bad name to everybody. It's like the bad nuts. You know, we normally don't talk of the good fellows. We're always singling out the bad ones. And when we've given the bad ones the bad name, then we multiply it to affect everybody. My simple point is that we need to be very careful when we're dealing with this issue of judicial corruption, because Ghanaians, as a people, we know that there are bad nuts. Let's say there's a mensa in every home, as we say. But I will put it that when you take 10 judges, I will pass 9 of them. That's the way I want to talk about. I don't also believe that there is going to come that we will have zero corruption. It will not happen. It has never happened. From the Garden of Eden to date, corruption will exist. But what we're trying to do is to minimize it, put in structures and put in all those kind of things to ensure that it becomes virtually non-existent. And therefore, that does not give a name to everybody who finds himself there. That's my view of this matter.
I see. Abdullah, I mean, you guys work, you are you guys work with the system. You are the wheels of the system, really. And so Justice Stockton made a point about predators. People coming to you to say, okay, give me money. This judge, the judge wants money, I should give it to the judge. It is often people from your side, the judicial service staff, who do that. The clerks, the registrars, etc. If people are to do that, usually it's people from your fold. How do you situate that comment she made that indeed the money doesn't get to the judges often? It is a whole industry built around the judges. That directly falls to you guys.
Okay, thank you very much, and good morning to your viewers and listeners, and to my president, Mr. Samuel Afote Otu, our leader. And to my Lord Justice Tochi, the acting Chief Justice, and the incoming Chief Justice, our mother, and management and staff of the Judicial Service. The issue of corruption, in fact, it was one thing before I even joined the service that I was thinking about, especially when the Corruption Perception Index comes up. When my lady made mention of the predators, if you come to that industry, you will realize that it is not just, or it's not referring to the staff of the service per se. An incident happened very recently. People who don't know about how the court works, if they come closer to the court and they see anybody wearing a nice dress, in a tie, in a suit and other things, they say the person is a lawyer. Some even think that anybody working in the courtroom, whether the person is a court clerk, an interpreter, a bailiff, that person is a lawyer. So people come around the court dressed in a certain way that we think that person is either a lawyer or the person is also part of the staff. And by the nature of the way the person presents himself, if he approaches somebody wanting to help, especially in criminal cases where freedoms are at stake. I recall a case in Cape Coast where somebody came around like that and said he is a lawyer who was going to secure bail for a client, and asked them the amount of money that they had to pay, how much had to go to where and ever. Talk about those kind of things. He took the money and vanished. And when a complaint was made to our complaint unit, they had to do an investigation and finally discovered, when he gave the description, they discovered that this is a usual face that comes around. It has not been seen as being part of the bench in any court, but you could see that face hovering around. An investigation was done and the person was fished out. It turned out that the person is neither a lawyer nor a staff of the judicial service. So things like that happen. Of course, judges...
But these are isolated cases. Sometimes they come to the court, they see the clerks, they see the other people.
Yes, it is not really the... Look, when a counsel... I'm not saying lawyers will do that or police will do that, but a judge comes into the court and then a lawyer can come and say, my lord, I want to say hello to you. He comes inside and greets and goes out. A perception is created in the mind of his client, or a police officer might, I'm not saying they do, but might have had an engagement with somebody somewhere. He comes and he says, my lord, I want to say hello to you. He comes and say hello and goes back. If he had an engagement with somebody earlier before going to say hello to my lord, a perception is created that, oh, okay, what he took from me, he's going to give that issue to the judge. It will turn out that it is not the case. He just goes to greet and come out to create that perception. The person you're talking about here is not a staff of the judicial service. So in every place, like counsel said, you will find one or two people being engaged in things that are not supposed to be so. And currently, the judicial service is very strict on that. If you see our code of conduct, it's like when you are working, you even have to be careful about the way you work. And that has helped to clear a number of, minimize the such incidences in the service. So it is largely a perception. And what my lord was talking about was not referring to that in the predators industry. It wasn't about staff of the judicial service.
The predators industry is wider.
It's very, very wider.
All right, good one. Let me speak to Honorable Mahama Yariga. Honorable, welcome to the program. Of course, you sat in the vetting yesterday. You saw Justice Tokonu's demeanor. You listened to her answer and all of that. What ought to be your quick assessment of some of the issues she raised, especially in the context of judicial independence? Okay, I understand. I don't have on Mama Yariga yet, but Franklin Kujo surely is on. So Franklin, I'm sure you also follow the vetting, or you might have picked the snippets of it, here and there. What would be your general assessment of how she dealt with the matters, her record and everything, and situating that in the context of her views on bribery and corruption and even judicial independence? What would you say to that?
Good morning to you. Good morning to my friends and everybody watching. And to your producers, by the way. Well, I mean, I've known the Chief Justice nominee up close for almost 3 years. I was part of a user committee that was set up for the commercial court. And as it were, we were discussing how to accelerate, justice in terms of fast-tracking commercial court cases. And I recall that in one of the conversations we had, she was pretty much intent on making sure that Ghana was compared to the highly effective countries in terms of fast-tracking judicial service delivery. And I remember when she asked the question, how do we scale that bar where we are seen to be slow in terms of delivering delivering justice generally? And then I opted to help with data, and she obviously went ahead and said, well, just go ahead, and that led to us digging a little deeper into the cases. In fact, the Judicial Service was kind to give us data between 2011 and 2016. We did the analysis. Eventually led to a publication of how to attract entrepreneurs into the country, that issue about time as it relates to delivery of justice in the country, especially commercial court cases. So she was very efficient in my estimation, and I think, was it Esan Kuma who must have written something earlier about being a stalwart of company law, which I thought was going to be part of the conversations during the vetting, but unfortunately, well, that was not so much. So what essentially I think many know her for, and in this case, being the supervising judge for the commercial court, incidentally did not come out that much. But I, obviously knowing her up close and having worked with her for almost 3 years, I knew she was going to leave that legacy. I mean, I expecting that she'd leave that legacy. On judicial independence, though, I hope she's a bit more, going to be a bit more bold, and probably bolder than the predecessors, in ensuring that it's not just about the law. Sometimes, I don't know, I think we are too conservative in this part of our world Sometimes in American jurisprudence, you tend to find out that even though the law guides the whatever pronouncement, a certain level of independence and boldness that you see when you read judgments, you are so okay. But I mean, you feel as if you are in the ninth heaven. In this part of our world, and in most cases, I think there are a few judges I've also seen who do that. Justice Doche, maybe Justice. This gentleman, very erudite justice. I've forgotten the name. The name will come. Yeah, the name will come. Yeah, and then you see that they depart significantly from their peers. It's something I wish to see that she's going to imbue with the rest of her peers on the bench, because a number of times we need that. I'm saying this because we all had our own personal experience as Imani and other society actors who took a case against the Electoral Commission concerning birth certificates and all of that in the run up to the last 2020 elections. And I think her predecessor to be, well, her predecessor, because she's going to definitely get the nod, I think, made a comment which actually I was stunned. Essentially saying that we were neutral and that we were criticizing the EC. And I said to him, well, what were you thinking? That's exactly why we are in court, because we needed to criticize the EC. But not accepting the website and what have you. I found that comment very, very, very strange, and it sent shivers down my spine. And I wondered whether some of the comments that are being made by the political opponents of the current government may probably have some sort of some credits. Sometimes judges may have to probably shut their ears and eyes to whatever happens within society as it relates to certain cases, because everybody makes commentary, really, right? But you just have to stay close to the law. But in some regard, in asking for people to be bold as Supreme Court judges or judges in general, it's part of the conversation I'm thinking that should be had in terms of making sure that, yes, there may be certain things, strictures that the law may say, but again, you want to just jump and say, look, on this matter, I think my principles are probably much more pronounced than what happens to be the mechanistic of law. So I think she did creditably well, even though, as I said, I was expecting a bit more about what we know her for. But all in all, I think, we should be little blessed, probably more blessed, to have her as Chief Justice.
Very well, very well. So thanks so much, Franklin. So this is the big issue on 97.3 City FM. We're looking at the Judicial Service strike. We're looking at the Chief Justice nominees vetting yesterday, and some of the things she said, and a whole lot of things. My guest this morning, Franklin Kujo, Alexander Aban, Honorable Private Legal Practitioner, former MP Gumua West, Koku Pencil, Senior Lawyer, Managing Partner, Pencil Law, Abdullah Yakubu, General Secretary of JuSAC, and Mahama Yariga joins us soon, MP for Boku Central, member of the Appointments Committee of Parliament. We'll take a short break. When we return, we'll look at the minority's position on the matter, that they want the decision or the reasons for the decision or conclusions the Supreme Court arrived at in the Judicial recent matter. We'll look at that, and we'll also see what Justice Tokonu's view on the use of the tool of contempt is. I mean, she proffered a few thoughts on that. Some of the members of the panel or the committee thought that it was becoming one too many, how the Supreme Court issues summons for contempt on comments people make. We'll look at all of that when we return after this break. Don't go away. You're welcome back to The Big Issue on 97.3 City FM and on TV. This morning, the issues we are looking at include the state of Ghana's judiciary. We have the JuSAC, which is the Judicial Service Staff Association of Ghana, on strike since Wednesday. They've been on strike, and so justice delivery is ground to a halt in the courts, and that is a really, really serious matter. We are also looking at the new or the nominated Chief Justice. She appeared before the Appointments Committee yesterday. Justice Gertrude Tokonu, appointed to the Supreme Court or to the High Court in 2004, between 2004 and 2012, to the Court of Appeal between 2012 and 2019, and in the Supreme Court from 2019 December. And in April 2023, there was a nomination as Chief Justice, and that is what we're doing currently. We're going through the processes to get her properly appointed as Chief Justice. And yesterday, she made the Appointments Committee, and she was vetted generally on quite a number of issues, and we're looking at some of them on judicial independence, the use of the contempt tool, birth certificate, bribery and corruption, etc. So that's where we are. So Justice Eniyaboa is retired officially, so he's no more CJ. He retired on the 24th of May, which is about 3 days ago, and he joined the High Court in 2002 and moved to the Court of Appeal in 2003, stayed there till 2008, went to the Supreme Court after that, and then retired just this week. And he's been CJ since January 7, 2020, till this week that he retired. His legacy, the president says his legacy has been stellar, a lot of infrastructure projects, etc. Of course, the minority also have their own views on him, the NDC particularly. But that is the nature of his legacy. That's what we're trying to look at today. And also in the second part of the show, we are looking at the IMF deal, what it means for the financial sector, and generally the public, the squeezes we have to endure, etc. The show, as always, is interactive. You can join us via our WhatsApp line 020-444-7033, 020-444-7033. We'll be happy to share your views with the rest of the world. My name is Selom Adunu. So my guest, Franklin Kujo, President Money Africa, Alexander Aban, private legal practitioner, former MP, Gomoa West, Kweku Pencil, managing partner, Pencil Law, private legal practitioner, Abdullah Yakubu, General Secretary, JuSAC, and then Mahama Yarega, MP for Boku Central. So, yes, let me come to you, Honorable Aban. A number of things were also said. For example, this week or the week before, I think this week, the Supreme Court issued a summons to Pesa White, Dr. Pesa White, for some comments he made. The Supreme Court felt that the comments scandalized it. And so he is to appear before the Supreme Court. People have thought that the Supreme Court is too sensitive to criticisms, and that should not be. Employing or deploying the tool of contempt, that way will stifle free speech and all of that. That question was put to Justice Tokonu. He said the contempt tool has always been used, and it's been used to protect the dignity of the court from being scandalized. I don't know what you think. What do you think generally about that summons and the response given by the Chief Justice nominee?
Thank you very much. In any well-established democracy, one of the indices to see that there is proper democracy is free speech. And if you look at Article 162 of our Constitution, it grants that. And over the years, you realize that the NPP government, for instance, tried to remove all these seditious libel and all those kind of things to make sure that people are able to express themselves freely. But in the same Constitution, it says that free speech is not at large. There are certain restraints to make sure that the exercise of that free speech does not degenerate into chaotic situations. So there are limitations. Because you cannot just say anything just because there is free speech. I want to first underscore that. Nobody is saying that the courts, the judges, and most importantly, their decisions are sacrosanct. Otherwise, you will not have review of laws, review of judgments. When you go to the University of Ghana, you have University of Ghana Law Review or Law Journal. Review of Ghana Law is also there, which is published by the Council for Law Reporting. Sometimes they take a decision of a court, do a serious critique. At the end of it, when you read that critique, you realize that no, the judge must have been wrong. Those people are never called and condemned by the courts because they are not attacking the personality of the judges. They are not attacking the court itself. They are attacking the decision, the reasoning. And so somebody can pick a decision, do a critique, and even say that this is an unsound judgment. He will not be in contempt. We must draw the lines very well. But what you have to know is that the three arms of government, the executive, the legislature, and the judiciary, the executive may have their own ways of making sure that people are compliant. The legislature has contempt of parliament. The judiciary also has contempt of courts. And this is an age-old tool in the hands of the court to ensure that its sanctity is preserved. And I can assure you that the bulwark of democracy are two, the legislature and the judiciary. These are actually the two areas. When it comes to the legislature, because of partisan considerations, sometimes you realize that the only way to make sure that democracy, the wheels of democracy run so smoothly, the bulwark that would ensure that there is balance in everything, is actually the judiciary. And once confidence in the judiciary is lost, once people can just take it for granted, we are doomed. And so it has always been a tool in the hands of the judiciary to ensure that people comply with orders of the court. And so when it comes to contempt, there are many, many things that go into it. Either the court has made an order and you refuse to obey, or the court has made an, for instance, a restraining order and then you go against it, or an order compelling you to do something and you refuse to do it. Or, for instance, you insult a judge, you insult the courts, or you even prevent witnesses from even testifying. All these things come into what we call contempt of the court. So long as the effect of that is likely is to bring down the image of the courts and to make the right thinking members of society feel that, oh, after all, the courts don't mean anything. So long as it has that effect, it is contempt.
But of course, that is well known. But that tool, people think, should be used sparingly. But when it appears that at the least provocation or the least thing that is used, doesn't it become
Indeed,
a difficulty?
they use it sparingly. I can assure you of that. There are many, many things that people do that may constitute contempt. But the courts do not every time call people, hold people before them to answer questions. It is usually used in situations when they think that, look, enough is enough. It is getting too far. So where this matter has got to, we need to bring some sanity in the system. We need to at least let the person know that what he has done is likely to reduce confidence in the judiciary. I mean, if we should reduce it to the Dr. Kesa White's, he's now a professor, right? Professor Kesa White's comments.
But have you seen the tweet that the specific tweet that
I read it.
Okay, and you think that was contemptuous of the court, or that tweet merited a summons?
It was extremely contemptuous.
Because when you look at his timeline,
look at his learning. Look at his learning.
Yes.
He's a professor, for Christ's sake, and he's my very good friend. I must state that here.
You guys were contemporaries at Investor.
Yes, without destroying our friendship, I must tell him in his face that what he wrote, probably he was carried away by partisan considerations.
But he said he was reading. He was reading some documents, some book. Of course, I've looked at his timelines, and indeed, a lot of the comments on the courts were U.S. related. So, for example, who else is following developments related to the U.S. Supreme Court? It is said how the court has shifted to the political right instead of staying in the middle. God save our democracies. Other ones, there's a story from the Hill. The American public no longer believes the Supreme Court is impartial. He commented on that. Thanks to all who have, and he said, thanks to all who have called, who have asked questions about my May 19, 2023 tweet. For the avoidance of that, I follow judicial decisions in many countries. So the said tweet cannot be pinned to Ghana. It has more developments. It has more to do with developments elsewhere, including the U.S. We live in a global village, etc. So the point is that maybe he's been on a roll, so he's been commenting generally on decisions elsewhere. Fortunately or unfortunately, I mean, he's deleted that tweet though, so I'm unable to track exactly when he made that comment. Said it was not in relation to the Judicial Committee, Judicial Court or decision. Maybe it could have been coincidental, and so he needed to make that point, and he did. He also made that point in his apology and retraction that he was reading some other things, and so it should not be pinned down to Ghana. What do you make of that?
Okay, it is because probably of the hypocrisy that we show in Ghana. In the U.S., it is always there, right? Either the judge is a Republican or he is a Democrat. We cannot run away from that.
Yes.
In Ghana, if you say you are MPP, problem give you. If you say you are NDC, problem. Because of that, the judges are always trying to,
to be in the middle. But that's difficult.
But in the US, it is open. And one of the things that Donald Trump had the benefit of doing was this time round, because of the vacancies that came, he succeeded in getting conservatives to the bench.
And they stay there forever, so.
Yes. Okay. And they actually turned the balance to the conservatives. And the first blow they had was to go at Roe versus Wade, right? This has been a very long-standing decision for about 30 years. Yes, but they came to change it based on their philosophy as pro-life people, as conservatives, right? So on what basis would anybody say? Because you cannot say that judges are also not influenced by their own ideologies.
I see. So yes. So I think when you take a trip down his timeline, you see that as far back as August 2022, he made other comments on the Supreme Court because, I mean, he said he was reading a book, David Kaplan, The Most Dangerous Branch Inside the Supreme Court's Assault on the Constitution. All of that. So I think all of that must be taken into context. And I'm sure the Supreme Court will do all of that. Let me go to Mahama Yariga. Mahama Yariga, welcome to the program. You were at the Appointments Committee yesterday when Justice Tokonu appeared before you. In a few seconds, what will be your general assessment of her performance before the committee yesterday?
Thank you very much. I think she did a very brilliant job before the committee. I think she was impressive. There's no doubt about that. And looking at her CV, I think she has that diversity of experience that you need for an administrator of the judiciary, somebody who will oversee the judiciary. If you look at the CV, you see that she's had some management training, she's had training in the area of IT. In fact, she's been overseeing the e-justice program. She understands the technological issues that provide the infrastructure base for virtual infrastructure for e-justice program and all that. So for me, I think that, and in terms of experience, she's risen from appeal to the Supreme Court, and she's been on the bench for a while. So there's really nothing lacking in terms of the potential to be a good Chief Justice. And so I don't think that there's any doubt or any question about administratively capacity to function as a Chief Justice.
Very well. So what will you say to some of the views she expressed in terms of judicial independence, where she says that the unanimous decisions that we have seen in the past or we continue to see simply means that, the law is on the side of that matter, and it doesn't necessarily mean that they are towing the line of their appointor, for that matter. She also talked about bribery and corruption, and as you just heard your colleague, Alexander Aban, we're dealing with a matter of the use of the tool of contempt. Putting all of these views she expressed together, did you have anything contrary, or do you think differently? What do you make of those views?
I really don't think differently. I think that as a lawyer, if I have an issue with a unanimous decision, I go to the ruling and then the reasoning given in the ruling. If I cannot attack the reasoning, then I really have no basis for being concerned about the fact that the decision was unanimous. So for me, I think that professionally and intellectually, and then the quality of argument that inform the reasoning is, for me, the most important consideration. And so I prefer that when people have issues with a Supreme Court ruling, they present a reasoned critique of that ruling and not just engage in what I would consider as just, political talk, even though people are free to also express themselves. And indeed, it is the reason why I have consistently said that it doesn't do the image of the court any good if they hand in decisions without providing reasoning. Because I have consistently said that, at least I have some little learning in the area of constitutional law and some little learning in comparative constitutional law. And, if you understand the history of constitutional courts as political entities, you will also understand that their authority is largely founded in the quality of their reasoning and how they are able to mobilize the prevailing political forces in the country to back them, because sometimes their actual adversary is the government itself. You will think that at all times the adversary of the Supreme Court will be political opponents of the existing government. But there could be times when the actual adversary of the Supreme Court will be the government itself, and the potential of their decisions being enforced by the government will be affected by the fact that the government is the one on the losing side of the case. And yet that decision has to be enforced. And so at that point, it is the moral force behind the decision, the quality of the reasoning, that will galvanize the population to stand behind the court against their government, so that the court will prevail as the constitutional, independent arbiter of disputed and contested understandings of how a country should be run. And so, given the reasons and the quality of the reasons is at the very foundation of the legitimacy. It will be good when you are taking the decision to also give the reasons then. Otherwise, you give a gap, and that gap tends to be filled by political attacks on the court. Even later on, when you give your reasons, you would have lost the momentum because people may not go back to pay attention to the actual reasons that informed your decision, because they've already bought into the political propaganda that followed your decision, and you don't have an opportunity to correct it and reposition the court in terms of its image and relationship with the public.
Very well.
Also because,
yes, so Honorable, so I see you have almost segued into the, I mean, so that's been your principle and your view generally on the reasons, you know, going with the decision or the conclusion. So let's get into that. The minority has taken a position. Indeed, you issued a statement. Your chief whip issued a statement to confirm that, and you said that on the floor of the committee, and your leader also said that before the whole thing started, the whole vetting exercise started. But will it be fair to defer the approval from your side of the nominee, Chief Justice Chief Justice nominee Tokonu, based on a 7-member panel decision? She was just a member of that panel. Never mind, it was a unanimous decision. Will it be fair to withhold her approval, at least from your side, based on a collective decision? When she has hundreds of other judgments you could use to assess her.
Yeah, it will be fair to do a very good job of evaluating her. And given that we have the authority to decide basically what considerations will inform our evaluation, aspects of her work. I've just told you that we were very impressed with her CV and her background and her training and her preparedness for the work. But then also, we're looking at the way that the judiciary has been managed in contentious political matters, and we wanted to make that point. And the Question case was just a typical example of how the management of a case is creating a political situation. And we said, look, this is just an example, and you were part of it. But apart from that, we're also interested in your philosophy and, the kind of arguments that you would give to justify the decision that you took to take one of us out of Parliament. We want to see the quality of the reasoning so that it will enable us to move forward. And so we're not deferring her approval because she was not going to be approved yesterday. She wasn't going to be approved yesterday. Yesterday was just a stage in the process of her approval. The approval will ultimately come from Parliament when it resumes at plenary. We haven't gotten there yet. So we said, okay, as part of the process, there are timelines, and luckily, Parliament is not yet sitting. We resume on the 6th. Luckily, the Supreme Court says they will take a decision on the 7th. So we would prefer to wait till the 7th after we've heard the ruling. We might want to ask you a few more questions about the ruling as part of our evaluation exercise. It doesn't mean we'll vote against you, but we still want to satisfy ourselves. And then our friends said, no, you have to take a decision today. We said, no, we're not ready to take a decision today. In any case, the approval process, Parliament is not sitting. So why are you in a hurry? And they said, no. So, okay, if you want to go alone, go ahead and go alone. We are not ready to take a decision. So do whatever you want. And then they sort of, then we are going to interpret it to mean that you voted again. So we haven't said we have voted or we have voted again. We are saying that we are waiting till the 7th. And when we hear the reasoning and we want to ask a few more questions, we will ask for an opportunity to answer those questions. And then we'll tell you what our position is on the matter before a report is written and presented to Parliament, whether she will be a consensus candidate or, we'll have reservations and therefore we'll put her to a vote. So I thought that it was a matter that our colleagues on the other side will view it more as, the kind of adjustments that we need to make for each other to make each other comfortable about taking certain decisions. But it was like, we are the majority and so we must decide. I would say, look, you will unnecessarily punish her because you will rush and then take her through a process that would involve she being voted on. And that won't be our fault. It will be your fault because we're only asking for 7 more days. So, the 7th, to take a decision. So that was it. Now, whether or not there is justification for assessing her based on a decision of a panel of which she is a member, I find it a very, very lame, argument to say that because she's a member of a panel that takes a unanimous decision, she has no ownership of that decision. Come on. Any lawyer who understands constitutional law in the functioning of the Supreme Court will tell you that when there is a unanimous decision, it means that every member of the panel agrees with the decision and takes ownership of that decision and will live to defend that decision. If you have a contrary view, even though you may conclude with the rest, but you have a different reason for arriving at that conclusion, you have a right to say, yes, I agree with the decision, but I will arrive at it based on different reasons. And you are permitted to state your different reasoning for arriving at that decision. So if you don't state different reasoning for arriving at the decision, it means that you accept that reason. And once you accept that reason, you are equally accountable for the quality of the reasoning. So you can't tell me that because she is a member of a panel of 7, therefore she is not responsible or accountable for the reasoning that she uses to arrive at that conclusion. Is a manifestation of a very, weak understanding of constitutional law and how the Supreme Court functions and how individual members of any panel should be held accountable for the reasons that are given for decisions in the court. So yes, she is accountable for whatever reasons they gave, unless she either dissented or she agreed but gave different reasons, for which it is the reasons that she gives individually which should be used to assess it. Otherwise, the reasons that are given by whoever wrote the judgment, whether it is her or a different judge, she is accountable for the content and the quality of that reasoning.
Very well. So, well articulated. The chairman of your committee, Joseph Wusu, has said there will be no opportunity for a second vetting of a sort. That is, if you look at the reasons and you think there are issues to be clarified, there will be no such opportunity because he gave everybody the opportunity yesterday. So as it stands now, they, from what we know, have gone ahead to give their approval. And so they are writing a report, or the committee is doing a report, which will suggest that she's been approved by a majority, which then means that she will have to go through the process. What does that mean? Would the minority meet and say, okay, based on the answers she gave and her delivery at the committee level, we are satisfied, notwithstanding the fact that we do not have the reasons for the Judicial judgment. So even though we wanted to wait for June 7, we also give our approval. What will happen? Has that discussion been held yet? What will happen from here?
You watched the proceedings live. You heard me when it got to my turn. When I said my understanding is that there is an understanding with the chairman of the committee that after the ruling, we'll be given an opportunity to question her on the ruling. And I said my questions will relate to the ruling. Otherwise, I don't have any other issues with her nomination. If you watch the proceedings, the chairman did not, at that point, respond to me that no, you either ask your question now or you never have an opportunity. He appeared to have acquiesced and said, okay, I said I had no questions until after the ruling. Presumably, he agreed with an earlier understanding that he had with our leadership. Our leadership reiterated that point throughout the proceedings. He did not state categorically that he disagreed, and therefore, if we did not ask our question, he will not give an opportunity for second chance. He did not at any point. I don't recall, and you have the records of the proceedings. So it now becomes a question of his integrity as a leader. If he says that, oh, after the proceedings, I'm satisfied with whatever she has said, so I'm not giving you an opportunity, and the rules, there's nothing in the rules that say that we were compelled to conclude our deliberations yesterday. The rule says that when the committee concludes its deliberations, so it's up to the committee to decide that it has concluded its deliberations, and therefore it is writing a report. We could have concluded yesterday that we haven't concluded our deliberations because some members of our panel want another opportunity to question the accused, the nominee, and the nominee will be recalled again for that. It's entirely up to us. It is arbitrary and just, a show of power to approach it and interpret the rules the way that he did, but everybody and their limitations. So I cannot question his understanding of the rules and etc. and how he chooses to understand them. But you can read the rules. They are clear that when the committee concludes, the committee can say we haven't concluded. So you can't say there's no room for further deliberation. Now, secondly, it's up to him for he being on the majority side and he being a member of the party that nominated the nominee for the post of the Supreme Court, that is the NPP. His job is to make it smooth and easy for her. If he has to make adjustments to achieve that objective, it's an indication of his leadership quality. If he thinks he's going to be rough in his approach and in the end take her through a rigorous voting process, it's up to him. We yesterday said we haven't taken a decision on her yet. We haven't told you we are voting for her or we are voting against her. We just want to hear her reasons for deciding that our colleague, Honorable Quayson, should be taken out of Parliament. Her reasons may be well-founded. And if the reasons are well-founded, we will be among the first to say, oh, okay, we did not advert our mind to this provision of the law and that provision of the law, or we read this provision of the law this other way and she read this provision the other way, and we think that her reasoning are superior to our reasoning, and therefore we are preparing ourselves, we are going for a by-election, we are not going to file for a review, we will go and fight the case, the political case on the ground in the constituency and come back, let's go ahead, let's approve her as a Supreme Court nominee without having to vote, and etc. So we may come with a position either way. All you needed to do was to say, okay, well, in any case, Parliament will not be able to take a decision on her before the 6th because we are not sitting.
I see. So she also said a few things. I mean, this is the last question.
Why they had it? Let's wait.
Okay.
Yes. So basically, that was it.
Very well.
With you.
Very well. She also dealt with the matter of the tool of contempt. One of your colleagues, Professor White, has been summoned before the Supreme Court. And so I'm sure that, triggered a lot of the questions on contempt that she dealt with. So what do you think of what she said about the use of the tool of contempt? And did you see what your colleague, Professor White, tweeted, for which reason the Supreme Court is summoning him to appear before them? How do you juxtapose that comment tweeted and the defense or justification given to the Supreme Court's use of the tool of contempt in summoning your colleague before it?
Well, I mean, in all sincerity, I have not seen the tweet. I don't know the content of his message. I was actually not in the country. I came the day before yesterday just to participate in this vetting process, and I was so busy I wasn't following what Professor White was doing. But I am one of those who, as a lawyer by training, believe that the Supreme Court should be protected. Protected because the Supreme Court itself doesn't have a police force behind it, doesn't have a military behind it. It survives on its reputation. So as much as I'm one of those that insist that the Supreme Court must be held accountable. And for me, its accountability is to the quality of its reasoning and its decisions. The fidelity decisions. I know that in this era of social media and information communication technology, people are robust in expressing their views. And sometimes people express their views without really being well informed. And sometimes people have an understanding of freedom of expression within a democratic framework in ways that may not really be appropriate. And so you cannot, frown on the right and the power of the Supreme Court, and not just the Supreme Court, but any other court, High Court, Circuit Court, whichever court, at whatever level, their right to guard their image. Of course, we need to balance that with the freedom of individuals to express themselves and to seek to hold the court accountable in terms of the quality of their work. So I cannot comment specifically on Professor White because I have not read it. But then also I am one of those that will admit that no matter what you say, given the way that sometimes people, express their views about courts without really understanding the workings of courts and the workings of the administration of justice, and they don't even understand the rules of procedure, and then they don't understand the law itself, sometimes they can be so ignorant. If you ask my colleagues in Parliament, sometimes they will say something about a Supreme Court decision, and I tell them, with all due respect, I actually agree with the Supreme Court on this matter, because I've read it, and I understand the reasoning, and the rigor involved in coming to that conclusion is well appreciated by me. So I beg your pardon. So many people criticize without really understanding.
I see. Thank you so much, the Honorable Mahama Yariga. I know you're on the road, and of course, thanks so much for taking time off to speak to us on these matters. Mahama Yariga, Member of Parliament for Boku Central, and he's key in this because yesterday he premised his comment on the unavailability of the Chikwesi reasons, and so we had to take some time to deal with it. Thank you so much, Mahama Yariga. Yes, Honorable Aban, you were on the floor, so now we segue into this. On the Professor White matter, we've heard views, I'll come to him. But on the matter of the minority, he seems to explain his point that she was part of a collective decision, and so she must own that decision. They wanted to test her view, really, on the decision they took to take one of their own from Parliament. They needed to understand that. And so they're saying that they should defer the vetting or even the approval of the nominee to when the reasons were available should not be taken out of place.
I'm not the host, but I wish I was the host. I would have asked him, in his own view as a lawyer, did Judge Kwesi qualify at the time that he filed his nomination, so that he would have even taken his own view to see. So are they doing this as a matter of law, or they are doing this as a matter of political consideration? That's what you must start looking at. Because if it crosses the line from being a matter of law, by that it is just a matter of political consideration, that is where we will say that of the many cases that the Chief Justice nominee has dealt with, they are only interested in this because of its political coloration. Otherwise, I don't think that that decision alone could be a reason to assess her quality or otherwise. Because this is a lady who, from 2004, has been on the bench from the High Court up to this point where she's in the Supreme Court. Many judgments have come out of her pen. And to assess her quality, you could use all these. Why the political question?
But that's where their interest is there.
That's what I'm saying. That is it because of political coloration, or it is because of her standing and her quality as a judge. Because if it's her standing and quality as a judge, there is evidence, enough evidence for them to come to a conclusion on their own assessment as to whether she's good enough or not, without necessarily looking at the judicial decision before. And that's why I'm thinking that we must not draw too much partisan or political partisan considerations into this. Because, I mean, there's a joke passed by a well-known NDC lawyer that I know. I don't want to mention his name. He said, oh, as at now, there's only one judge standing in the Supreme Court. And the rest are all politicians.
And the judge, that one is who?
And that judge is Kwamai.
Why
the
so?
Rest are all politicians.
Why
Most
so?
probably because, apart from him, all the rest were appointed by the president.
Akufo-Addo. Okay. I see. That's interesting.
So, and if you view that against the comment, the unfortunate comment by Dr. Pesa White, there seemed to be some kind of perception, okay, on the other side of the political divide, that so long as, and maybe I can go back a little more even to see the point made by Justice Atuguba, Professor Atuguba, on the research that he purportedly conducted. That's
about the appointment, the appointor and the direction of the judge.
Exactly. But when we do that, we weaken the confidence that people must have in the judiciary.
Life is a fact. Why don't we state it? I mean, that's research. It's shown that the judgments, the direction is same as the appointor. So if you appoint me and a political matter comes up, I rule in a way that favors you. If that's the result of the research, that's factual, isn't it?
No, but if it is based on political philosophy, for instance, like I said in the US, that you obviously know where the direction of a conservative bench is likely to be. And you are also able to predict where the direction of a liberal bench would be. If it had not been issues of hypocrisy and all that, some of these things must not come to us even as a surprise.
Yeah.
Right? But the question is, how many political cases are actually done in the Supreme Court? Very, very few. In fact, infinitesimal point
compared to what they do.
The number of cases
that go through the courts every
between individuals that come before them.
Yeah.
The only thing is that, and she said it right, because political cases usually are heralded by noise and news items and all that, it attracts the attention of the public. But you look at for instance, if I should use the Supreme Court of Ghana Law Report as a basis, you see that there are many cases.
Professor White has said that his tweet has nothing to do with Ghana's Supreme Court. That's what he has said.
Regardless of which Supreme Court he's talking about, you don't.
But he said the apology is about. He could have done better.
That's what I'm saying. That regardless of which Supreme Court he was talking, even if he said that it's about the U.S. Supreme Court, it's wrong.
I see. Very well. Let me go to Kuku Pinto. So the decision of the minority, deal with the decision of the minority, and we want to speak on the contempt as well.
I've got very strong views on the issue of contempt. Because first and foremost, you see, if you look at the fragility of the country and our institutions, you will appreciate that freedom of speech must be so well balanced that people just don't say anything. I want to give you the example of what happened in the U.S. over the last 2 years. I'm talking about the Trump sedition and everything that went with it. You notice that at the end of the day, we have the situation we have because the institutions are so strong. They've been built over so many years that the individuals who hold his own attorney general and so forth and so on, they all brought their influence to bear on the situation in such a way. Because you notice that Trump is of a different character. I don't know where he came from, but he would have his way in virtually everything. He could not have his way because of the strong institutions. We don't have them in Ghana. And therefore, when you begin to call names, stupid Supreme Court, it cannot be. Every country must have a lexicon.
Yeah, but it's not. You said it's not in relation to Ghana's Supreme Court.
Please, I'll come to that. He says Why apologize for what you have not done?
Said he could have done better. It takes
Not so,
responsibility.
please. You see, let me tell you, this is a hype. He claims that it's not, but if I really have not insulted you, I will not apologize for any reason. But let me tell you something that's happening in this country. I'm just using this as a reference point for other contempt matters that arose that were in Supreme Court. You see, what it shows is that we lack conviction as a people. In other words, people have views. You may possibly believe that the Supreme Court is stupid, but you must say it and defend it. It's as simple as that. Only last year, I was reading on a distance. I think a similar situation occurred, and I did a Google search. In India, a senior practitioner had called their Supreme Court by names. They brought him before the Supreme Court. They rendered a decision and gave him an opportunity to apologize, or you face the. You know what? He told them that to be a contempt of his conscience to apologize.
So he defended the position.
That's the real man.
So what happened to him?
Of course, he faced the consequences. That's what real men do. You know, I mean, say things that you believe. Come on, if you believe the Supreme Court is stupid, why don't you go and explain it to their face? Show them reasons why you think they are stupid and face the consequences. That's what we call consensus objectives. People have a conscience. They tell you, look you in the face and tell you that, yes, I know the law. I know this is the creed. But nonetheless, I will defy this creed for reason A, B, C. Everybody who defies the Supreme Court, he goes there and then he begins to render all forms of apology. You are no man.
Very well. Very well. So Abdullah, now let's get into the meat. Now, JuSAC is on strike, and we've been trying to plead with you guys to go back to work so that we can also work and people will get justice and all of that. Kindly take us through what your concerns really are. You know, for people who do not understand why you are on strike, why really are you on strike?
Thanks, the issues that brought about the strike by JuSAC borders on approval and implementation of review of salaries and related allowances to take effect from January 2023 to December 2024. Per our arrangement, the salaries are reviewed after every 2 years. Unlike other public sector who have annual review, we have biannual review. So when it's time for us to review the salaries, traditionally JuSAC will send a proposal to our management. And the constitutional arrangement is that the President of the Republic of Ghana will determine the salary based on the advice of the Judicial Council in one instance, and in another instance in consultation with the Public Services Commission. So when we submit our proposal to the Judicial Council, they often will set up a committee to look at it, so that a report will come out as the Council's advice to be submitted to the President for that determination to be made. So way back in October last year, we submitted the proposal for the Council to consider in their advice to the President. It took a bit of time, and the Council finally finished its work, and they submitted to the Presidency for his determination in accordance with the Constitution. It took a bit of time for the determination to be made, or we'll say the approval to be given. But what really also brought about the strike was the peculiar nature of the issues we're dealing with. Because government of Ghana introduced the cost of living allowance for public sector workers, largely because of the fall in real incomes occasioned by unfavorable economic conditions in July last year. And staff of the Judicial Service were part of it and did enjoy the COLA up till December 2022. In December 2022, the Council had not completed its report to be given to the President. So we could not have been, asking that we should be given the review, we should be given an approval. But in January, we realized that we were running out of time. So we had to plead with government through the Council that the cost of living allowance is still relevant. We knew it was supposed to end in December, but because we have not completed our review, the COLA should be maintained in the interim, so that the Council and government will continue to work on the review. As and when the review of the substantive salaries are completed, the COLA will be taken off and the new salaries will take effect, the necessary arrears. Unfortunately, that was not granted us. Then we came with another proposal that, okay, we are in January. Since you could not maintain the COLA for us, then quicken work on the substantive salaries so that we can have it enjoyed. And normally when you are dealing with workers, equity is very important, and people will normally compare naturally, and that has a psychological effect. When you increase other public sector workers' salary by 30% and withdraw the COLA for them, you take away our COLA also without giving us an increase. We go to the same market, buy tomatoes, pay for trotro at the same price with the other public sector workers. Once they have their increase and we don't have that increase, and the process was, like my lord said yesterday, slow. From January, we're hoping that by February, I think things could have quickened, because there are times that government will prioritize issues and make sure that they sit almost every day to see to it that issues are resolved for staff to get what is due them, especially in other public sector. I recall that in those who are on the single spine salary, when January was getting to an end, government had to sit with them almost every day and made sure that by 13th January, they concluded everything, submitted it to controller, and they had the salary in the month of January without any delay.
But when did you submit your proposal to the president, to the office of the president?
No, we don't submit to the president.
You submit it
to the council.
When the council forwards it to the president.
To the president, yes.
But when do you know that the presidency got hold of that document or that proposal?
When we made the Labour Commission, the official information given to the Commission by our management is that it was submitted on the 20th of April.
To the president.
To the president,
by
yes.
The council.
However, the Judicial Council completed its work on it on 29th March.
Okay.
Yes.
Okay. But between 20th April and now, that's about 1 month.
That's more than 1 month.
That's 1 month, 9 days, right?
Okay.
Given all that the presidency goes through, etc., won't it be too harsh to expect a decision on that in just the 1 month period?
It would have been okay if the government was minded to maintain the COLA, because the economic situation that brought about the introduction of the COLA are still prevalent. Mind you, at the time that the COLA was introduced, inflation was around 10, getting to 20s and thereabout. At the time that it got to the presidency and the COLA was withdrawn, we were now jumping to 54, coming down to 51, 45, and around 30, something like that. So given the situation that we found ourselves, it would have been okay that to give government even 2 months to do it, if they had maintained the COLA for us in the interim, so that we know that things are hard, but there is something that we are relying on. Then government could be given the space to work on the new salaries for us. Unfortunately, we did not get that.
I see. So as it stands now, what is the next move? I mean, the Judicial Secretary sends a press statement to say that you guys have a meeting on Wednesday.
Yes.
Before that meeting, are there other meetings with government or other people, expected to, or supposed to, who are required to deal with you to bring to a proper resolution of your matter?
Okay, if there will be a meeting, the government will meet us with our management. The meeting with our management on Monday perhaps will be a preparatory step.
So you have a meeting on Monday?
Yes, please, with management.
Okay.
And that could be a preparatory step towards another meeting on Wednesday with the government side, possibly Minister of Finance, and maybe anybody given a fiat by the office of the president.
So what are you guys looking for? Do you want the money to hit your account, or you just want an assurance that the money will be paid you?
I'll be frank with you, we've had assurances. And it's very common to be given assurance that may not come, that may not materialize. So the ultimate goal for JuSAC is to get the new salaries approved and then paid to us with the necessary arrears from January up to the month of approval.
Before you go back to work?
That is the ultimate we are looking for.
But then it means you are not going back to work now. I mean, and we've not even had, or you've not heard from government whether your proposal is been approved or government wants you to relook at the proposal.
Yes.
We've not heard that.
Yes,
and what proposal have you taken to government or the council for onward delivery to the president? What's the proposal? What's the increment you're looking for?
What the proposal we sent to the council was for 55%.
55%.
Because we have after 2 years, we have to go for review after 2 years. So it was 55%. But as to what the council submitted to the president and what the final outcome will be, we wait. When we engage, then we can look at those nitty-gritties.
Okay, so all of that hasn't been done, and now you are saying that you have to be paid practically before you go back to work. That appears to be.
That's what I said. That is the ultimate goal that we are looking at.
So it means you are amenable, or you are pliable to discussions and for that position to be massaged.
Sure. In fact, the strike is not what we want. It is the money, the approval, and the payments that we want. If that has to be done, there has to be an engagement. If we have the engagement and what is put on the table is convincing enough and assuring enough, then we can consider taking a second look at the position that we have taken.
So as we speak now, you are not calling on the strike on Monday. Monday, we are not working on Monday.
We are not, staff are not coming to work on Monday.
So nothing can happen between now and tomorrow for you to call up the strike, so we work on Monday.
Anything can happen. We are open. If they call us to come for a meeting on Sunday, we are available to engage with whoever is going to give us the necessary approval. But what the meeting we know of is the one coming on Monday.
And you won't call up the strike until after, maybe before the meeting. You will not do that before the meeting.
Before the meeting, no. The calling of the strike will depend on what is put before us when we go for the meeting. If you don't know what is going to be put before you and then you decide to call off the strike, then you are not doing yourself any good.
Kuku Pencil, you have dealt with the JuSAC guys in one of their seminal cases.
Yes.
What do you make of this position? Of course, for 2 years, their salaries haven't been reviewed. The COLA they were taking last year has been taken up. Yes. They are back to zero, more or less. The economic situation is very harsh. The economic situation is very harsh. Yes. And they are still buying from the same markets. Their colleagues in other public sector organizations have had increments to the tune of about 30%. Right. Is there justification for the strike, notwithstanding the fact that you are a practitioner, so it means you will not be working over the period? But is there a justification for their strike, given all the reasons adduced?
First, I'm quite sympathetic to their case, but that's a different matter. Strike is an issue of law. In other words, one of the rights that's granted by our Labor Act. A worker is entitled to strike, but subject to considerations that regulations of the Labor Commission. Labor Commission has the authority to call any striking workers to order, and they normally exercise it by issuing some form of order directed to them. I wouldn't know on the particular facts of this case what kind of engagement has taken place between the Labor Commission and the JuSAC as an association. But I would take the view that if the Labor Commission takes a decision requiring that they should return to work and they fail to do so, it will have consequences for them in law. In other words, every time that workers come together as a union, they look at a collective entity and they can be very defiant, even in the light of orders and decrees and so forth and so on. I do not know why in this particular case the Labor Commission, because typically they go to the court and get an order, a kind of injunction, which is mandatory.
Maybe they didn't anticipate it early, and now they can't go to the court to do that because the courts are not working. The very people who facilitate that are on strike, so the courts are not working. So it puts Labor Commission in a very difficult position.
I think they are very clever, whoever planned that one. But that is where the fix is. But as a rule, they're entitled to go on strike, but they also have to consider, because see, I've been involved in a situation or two where workers have legitimately gone on strike in situations where I was in a position of authority to speak about it. And then I raised the issue of the strike, the disruption that normally will follow these strikes, and the justification, if any, for them to earn their salaries or incomes or whatever for the period that everything has been disrupted. Because if you take the law, I mean, the fact that you can go on strike does not mean the strike is illegitimate. I want to put it that way. Because there are structures that have been put in place by the law that entitles to go on a strike. But you know what really happens is that a lot of these times, whenever the strike has ended, then it's like everything must go. But I tell you, time is coming in this country where the Labor Commission can go to court, and even after the strike, for a court to make a determination that the strike was illegal. Yes, whether the strike was legal. And if it's not illegal, then the consequences must follow, including losing your salaries or entitlements or for the period of the strike. You know, that is how these issues must go on in this country, because now everybody is aware of his rights and so forth, but right go with consequences, right goes with implications and so forth and so on. So maybe this is a test case where they have, I wouldn't use the word connived, I wouldn't use the word colluded.
But Labour Commission was on notice. I mean, they notified Labour Commission. I'm sure they did all of that.
I'm not making a pronouncement. Let me tell you something about notice. I was a student leader in those days. We did the university regulations about applying and so forth and so. What we do is at the time that we go on the strike, or the time that we go on demonstration, that's the time that we would deliver our letter asking for permission, which was an exercise that we deliberately engage in, of course, to frustrate any action. And that kind of notice cannot be a proper notice, cannot be a legitimate notice. But I'm not speaking to the facts of these cases. I do not know. Because if all that you do is to give notice that you're embarking on a strike in circumstances or a situation where you know that the kind of notice requires a kind of response before you can actually start it, then obviously when you confront the Labour Commission, what we call a fait accompli. In other words, a situation where they can't do anything about because of the very circumstances, and obviously in this particular case too, the court themselves are also closed down, and therefore depriving the court itself an opportunity to examine the legitimacy or otherwise of the situation. Personally, much as I sympathize with them, I'm hoping and believing that the matter will not end there. Because
there are people who think that the court people, the judicial service should be part of the essential services so that they cannot go on strike at will, or they cannot go on strike this way. So they add them to other essential services. Would that be a solution?
It may not necessarily be a solution, because at the end of the day, the statement that the gentleman made was very simple. Is that even if they had the money tomorrow, they may not be the meeting at all on Monday. That's all they are requiring. So the real purpose of making anybody, adding anybody to essential services to ensure that they've got a package. So it's the package that's going to, determine what the situation is going to be like. And, I've looked at the Labour Act. I've been involved in some litigation on these subjects, and you will appreciate that even though the pension, you see, we've got the Pension Act, you see, even though the Pension Act originally sought to remove even these essential services from Cap 30, which is a form of pension that existed, there have been a backtracking in respect to the, the essential services, meaning that they're entitled to a package which is better than what the ordinary workers are enjoying. So if the idea of adding them to essential services is to ensure that those are the packages that they are going to enjoy, going to be entitled to, I'm talking particularly about Cap 30, I believe I'm right. Yes. It's particularly about the Cap 30. Then it's a different form of pension.
Will you be amenable to being added to the essential services, or that doesn't come up in your discussions?
It doesn't come up in the discussion, yes. But if you look at the nature of the service we render and the regulations that governs our work, we feel that a package could be put in place to add us to the essential service, and then we enjoy that package. Like what counsel said, he happens to be our lawyer and did a very good job for us in a matter
versus AG and two others.
Very good in 2016. And if you check that case very well, you realize he made a very good case for us to be entitled to the Cap 30. And if we have packages like that, it should not be wrong for us to be added to the essential service. And that is if government is willing to get us the other benefits that comes with being an essential service provider. If you pay me as a salary that is so equal to the normal non-essential service workers, and you want to add me to essential services because you don't want me to go on strike,
that will not be fair.
That will not be a fair thing to be done.
Very well.
It should come with a package.
Franklin, I know you've been listening in. The strike, you may be a user of the court. The strike is affecting delivery of justice. You've heard Abdullah speak, articulating their concerns. How do you hope this is resolved? They want their money, or they want some serious assurance from government before they can call off the strike. Given that their strike touches on very critical part of our society, justice delivery, what should be the approach? Government obviously has difficulties. What should be the approach?
Well, I think before they deliver the help in justice delivery, they must be well fed. Look, I mean, if their due is is reviewed after every 2 years, I think that's what he said. That actually is not fair at all for them. I mean, on them, not at all. I really do not have much to say except to say that they should attend to their needs immediately.
I see. So they want a lot of the, how do you call it? They're calling for 55%. In this, of course, we are dealing with IMF after this discussion. This harsh economic situation, 55%. Never mind, it is for a period of 2 years. My difficulty is that they've not even received any acknowledgement from government in respect of what they have brought. And so that also means that going through that process will take a long time before their matter is resolved. And the difficulty that leaves users of the court with, that is my problem. Because a lot of people's decisions or actions are awaiting their strike. People must go to court to get other things done. It's a very dicey situation, if you ask me.
No, without a doubt. I mean, I sympathize with everybody who is using the courts. Anyway, look, I'm sure the 55% was taken into. I mean, they took into consideration the inflationary trends. Well, guys, inflation is already coming down. Maybe government could meet them halfway, and then I'm sure they are willing. They are human beings as well. They'll be willing to concede. I think that's what I read from the gentleman's. Language, right? I mean, if something is offered, at least that would be a starting point. But if there's been no acknowledgement at all, that's not fair on them, really. You know,
I see. I see.
Yes. That being charged at the courts are any lower these days, anyway.
Very well. Aban, I want to be calling you Justice Aban, but Alex Aban, I want to conclude with you on this. You're a user of the court. I mean, you practice in the courts. I mean, so you talk for yourself, but you have to consider their difficulty as well. I don't know where you draw the balance. You have to go to the court to earn your wages. They also work in the court, but if they are not well fed, like what Franklin just said, they cannot continue working for you to also be getting your due. Government hasn't responded to them. Obviously, the government is seeing some difficulty. Where really do we draw this line?
Oh, let me start by saying that I sympathize with, because having followed the trajectory of various engagements up to this point, I sympathize with the judicial service staff. You know, probably if the COLA had not been withdrawn,
yes,
and it was there in the interim as they continued with negotiations, probably we wouldn't have had this situation. Indeed, if you look at the economic figures, the inflation and all those kind of things, obviously, if government itself recognized that things were hard, and so this was introduced to cushion them for some time, it stands to reason that any time that you are withdrawing it, then you must put them at where they are supposed to be. And it is in that respect that I sympathize with them. But if you look at the timelines, how government works, sometimes slowly, it appears to me that the time that this proposal really got to the executive for them to work on it is so short for them to have embarked on the strike. And that's why I'm saying that probably the best would have been to maintain the COLA in their case as negotiations continued. We can only ask them respectfully that they should consider all other court users, because you have to know that it has collateral effects. We are talking about a third of the government machinery not working. And because the people who, if I say, patronize their services are also many, it's affecting everybody. And issues of human rights lies with them. Because as we speak, somebody may have been remanded. He is supposed to go for bail. Because they are not certain, the person will have to be taken back to custody. Now, somebody has an appeal to file within a certain number of days.
So in this case, what would the time be arrested? What happens? Time will still run?
I've seen a judgment. A judgment in which the court had taken judicial notice.
Which is of this.
Okay.
Yes. And said that, okay, you were supposed to file this your appeal or this process on a certain
there was strike. So
there was strike. You couldn't
freeze the time for you.
As I speak with you, I had some 14 days to file something in Kofodia Court. I had done everything that I had to do. And I felt I would file on the 14th day. Then the strike was announced the 13th day.
Oh.
What else could I do? So I'm sure all these things will affect a lot of things. So they should also know that, yes, as they push for their own sustenance and survival, they're also depriving a lot of us our daily income.
Very well.
So let us draw the balance and get them to go back to work.
You have the final word on this. What can you tell us?
Yes, please. So there's an issue about the Labour Commission which I want to make clear. In our case, we decided to give them notice. At the same time, wrote to the presidency through the council asking that if by a certain date we don't get what we are looking for, we'll be compelled to advise ourselves. Our notice to the Labour Commission was clear that if we did not get the approval by 12th of May, we were going to embark on a series of industrial actions. And we're being moderate because of the essential nature of our services. We first said that we're going to begin by wearing of red armbands to work from 15th to 19th. We'll come and work all right, but with the red armbands to send a signal.
Which you did?
No, we did not.
Okay.
After the 15th, then the following week, if you don't get it, then we'll now begin with a strike. The red armbands would have drew an attention. The Labour Commission issued summons to us to come, and Finance Ministry and Labour Ministry, and copied the Office of the Chief Staff to come and ask that the strike, we should call off all industrial actions. We appeared before them, and when we appeared, we look at the timing, the timelines that we were given, trying to strike a fine balance between the two and ask that they should give us, just our last thing was they should give us 1 week and order government to engage us. They did order government to engage us and ask that the Labour Ministry should convene the meeting with us to consider the issues that we are looking at. At the time that we were not embarking on any form of industrial action, the Labour Commission said no and adjourned the meeting to 24th. That is giving us 14 days. And said that government has a lot of business, so 14 days would be reasonable for the government to have engaged us and concluded the matters. So in fact, when we declared the strike on 24th, it coincided with the exit of the Chief Justice and others, and people were thinking that, no, it was the commission that gave that date, that we should come back on that day. Unfortunately, within the 14 days, government didn't take any step to engage us. We do not have any, not even an informal communication from government side within that period. So that brought about the issue that we have. Also, the Labour Commission gave its directive and wrote a letter. You see, the directive was dated 9th. We had a meeting on 10th. So
there was an issue with the date, which you guys raised.
So they withdrew that directive and said they will replace it.
So there's no directive.
There's no directive before us. So on 24th, there wasn't anything binding on us technically, so we had no option but to declare that strike. Then also, I want to add this issue is very, very important because I've gone through City News Online and the CTFM Online to get those issues. We say we are essential service providers. We've embarked on, for the past 8 years, JuSAC has threatened or embarked on 5 strikes. 2015, we went on strike because of salaries review. In 2016, we threatened strike, and I could see CTFM say, well, JuSAC threatens another strike again over salaries review. That time we had to consolidate our salaries. It came there. Then we had another one in October 2017. It means we're due for another review. And JuSAC had to threaten strike. November 2019, JuSAC threatens strike. We actually declared a strike in 2019 and certain issues happened. In 2021, October 2021, we had to declare another strike.
So the point is that every time
2023, we are also almost every 2 years it starts to happen. We've never seen Parliament say they want to declare strike or the Chief of Office of the President say that staff there are declaring strike. Among these 3,
maybe the next 2 years.
No. So the point I want to make here is that it is time for government to prioritize the service rendered by the third arm of government.
Very well.
And say that this is going to be the last of it.
Very well.
If we have that commitment, hopefully they will have a new Chief Justice going to come.
Very well. So that's
Abdullah
Yakubu, General Secretary of JuSAC. So that's how we conclude this segment of the program. Two messages. So there's some public service, and there's a ghastly accident on the Temamoto Way around Kanewu. The victims need urgent attention, and so we are pleading that the authorities move there quickly. This one from Max from Adenta says, I think the word contempt here is being misinterpretative. For instance, if I say we Ghanaians are fools because of a behavior I noticed from us, does it mean that the president should call me to order? That's from Maxwell. This one says, Salon, kudos for the extensive coverage your network, CTF and CCTV, have been giving and continue to give to the plight of the staff of the judicial service. May God richly bless your network. Salon, can you imagine the unfairness and injustice being meted out to the staff of the judicial service? And you give a long, so this is for a worried staff from Bono. All right, so this is how we conclude this segment. The next segment will be on the IMF. Thanks so much for doing the listening. My guests have been Mahama Yariga, Alexander Aban, Koku Pinto, Abdullah Yakubu, Alexander Aban, and then Franklin Kujo will continue to be on the next panel. Thank you so much for doing the listening. We'll be back and deal with the matters of the IMF. This is the big issue. Don't go away.
True to our game, it's time to ignite your passion. Astonishing. Thrilling.
That's great effort. It's a fabulous goal. What an incredible goal.
Electrifying.
And the pointer has got a goal.
Invigorating.
How good is he?
Stay in the game. Catch all the upcoming entertainment of this season on SuperSport, only on DSTV.
This Sunday on the Upside Down Show, we'll have a conversation with Princess Koko Boateng, Ghana's youngest qualified chartered accountant at age 18. She will speak about her experience on campus, life, and family.
I want to be someone who changes the dynamic of things. I don't think change comes in boom, big like that. It starts from the little stuff. So in my workplace, I would want to contribute significantly.
Continuously, and then we are being asked to front load them in our management of the economy. The same thing applies to the condition relating to revising the Bank of Ghana Act and ensuring that there is zero lending to the government. We ourselves, in the last IMF engagement, the IMF asked for zero lending, but when our government presented the bill to Parliament, after the deliberation, decided to peg it at 5%. That was the law, but the IMF was not satisfied. So the IMF requested from the government to put in place a memorandum to indicate that they will not adhere to what our law says, but they will adhere to what the IMF wanted. That was the zero funding. And we were told that in 2016, that was the case. There was zero funding of the budget by the central bank. And then along the line, we went far above the 5%. And I do believe that we can run this economy without allowing some space for the central bank to support the funding of the budget. But there might be a reasonable limit that all of us will adhere to. But I believe, again, we fail to adhere to what was provided for. And as a result, we have gone way back, and the economy has been engulfed with what we call fiscal dominance. And it is that fiscal dominance that we want to deal with. So in order to deal with the fiscal dominance, then you need to ensure that you restrict the central bank from lending to government. So these are the reality of the conditionalities imposed on us. And unfortunately, when we are in economic crisis and the rest, the usual thing to be done is front load all the excuses and difficulties on the public, and for the public and businesses to take the chunk of the load, and perhaps government may not be taking any of the load, transferring everything to those people who were not the cause of what we are going through.
I see. Dr. Ituahene, if you're on the line, I mean, you deal with the banking sector, the financial sector, and all of that. Is there any way, because the banking sector really has suffered some issues in the past, I mean, the cleanup and all of that. So just when it was getting onto its feet, we were hit by the DDEP. We've seen the financial reports from these banks, and a lot of them do not actually look good. Is there a way that the Bank of Ghana can help lessen the burden that these financial institutions are carrying? Is there really a way around this?
Thank you very much. There is a way around it, but it's a tough way to go. Because what you have seen, what has been taken in 2022 is not all. It's not all. The losses are not all. I can assure you that the total loss, if you use the 16%, what the IMF and the Bank of Ghana and the banks agree, the total NPV losses is close to 37 billion. As I speak to you, 19.4 billion was taken up in 2022. We're still left with about close to 17.1 billion losses that has to be taken care of. That is why the IMF is saying that front load all the losses and then develop your capital plan. Front load all the losses means that capture all the losses that are pending. Because some of the banks, I can assure you for the figures I have, about 5 banks managed to capture all their losses in 2022. But the others were given leeway to do that quarterly. If you look at the IMF report, quarterly capturing, where every 1 year you capture a quarter. Unfortunately, now you have to front load the losses and then develop a capital plan. And that capital plan would mean that the shareholders would have to come and support the bank to bring it to its solvency. Other than that, it's not going to survive international business and even local business. And the interesting thing about the way out, if you look at the way the Ghana Financial Stability Fund, if it's done perfectly, maybe will mitigate some of the losses. But if you tell the shareholders after the first capitalization 2019 or thereabout, to come and bring in so much money for the fault which is not the banks, if the fault which is not the shareholder who has created it. Although the board failure, governance failure, and poor risk management led the bank into where they are. But even that, if you call on the shareholder to recapitalize these losses, whereas the government himself, the state, has actually brought about these difficulties, I think that we should look at the supporting the Financial Stability Fund to help all the indigenous banks. Because if you have read it, all the foreign banks, I can assure you, South African banks, even the English bank, the French banks, they all, if you look at what Bloomberg said, they all started, even Nigeria, most of them are getting ready to capitalize their banks. So what I would say, the way out for us is that we should begin to support the indigenous bank. And like Professor Gachi said, we need to put up a very good corporate governance. You know, you don't load people to these state banks where people do not even understand what the risk means. We find ourselves here. Number one, it's a complete risk failure on the part of the board. So you can hold the board responsible and then hold the risk management board responsible. But the total ownership of the problem is, to me, is the state which borrowed and borrowed and borrowed and borrowed and borrowed. And one time in a lecture at Kimpiski, I said that when we are borrowing out and not putting into productive use, a time will come we pay through our nose. And that is why Professor Gachi is saying that We stood aloof for people to take the whole country for a ride. That is the price that citizenry have to pay, which is not fair at all. Which especially the owners of the banks, especially the indigenous bank, who the shareholders have tried all these while to bring the bank, then for them to go in the way they went, to actually say that. So that is my plead with the authority, is to build a very good, like this, the Jamaican Financial Stability Day. You need to build a strong financial sector stability fund that will go to support the indigenous bank. Otherwise, if the impending losses are captured by 2022, it will be very difficult for the indigenous bank and the Ghanaian banks. So that is what I will say for a moment.
So supporting the indigenous banks, what does that mean and how should that be done? Are you recommending the GATT approach, for example? How should that support to the indigenous banks you're calling for be made?
What we have done, what we've done, this debt exchange is a replica of what Jamaicans did. So even the financial stability fund is based on the Jamaican model. And what they did is that the central bank created a stability council that would ensure the need of every institution. I don't want us to create another arm. The more you create these guards and this one should be the focus of the central bank, so that the board of the central bank or the board of the Financial Stability Council would ensure that every bank's need has properly been dealt with. Because if we are borrowing from international market to support the banks, we must all take the responsibility that we shouldn't shift the goalposts. We should be tough with it. And you see, these funds are not free. The stability fund is not going to be free. If you read the literature, there is a little component of interest so that the physical costs do not come to hit the country. So we'll give you, and we also have to have part of the board. Bank of Ghana may have to appoint certain people on the boards of those banks that will be able to assess this fund, so that the governance, I want to state, the governance of the banks will be up and going, so that we don't find ourselves. But going to the guts and all those things, I don't want us to add. The more you add layers, the more you create difficulties, the more you create challenges, and the more you even add cost. But in the Jamaica model, it is the Central Bank of Jamaica, the Stability Council, that set it up so that they can look at every case individually and locate money as it is. But the question is that, is the fund even available? The question is the funding, because you hear that the World Bank has made a commitment of 250 million. Yesterday I read from, I think, one of the Minister of Finance, State of Finance or what is saying, he's talking to the African Development Bank to help us. You see, my brother, it goes to something that has been with us, like Professor Jachike said. Anytime we have a problem, instead of we looking the problem from down, we tend to look at the problem from up. If we have done serious scenario testing before the DDE, all these things would have been addressed. Because I wrote a paper and I said that banks will be expected to present a credible capital plan to the central bank during the DDE, so that the Bank of Ghana would have known the impact of every bank. But that has already happened. I believe what the IMF has said, like Professor Gachi said, anytime when somebody speaks from outside, we tend to run to embrace it. But when we speak from internally, our voices are not heard. So I hope and pray that all these things that we are saying will be taken in good faith, whether it's Professor Gachi, whether it's Franklin, whether it's myself or other people. We speak because we are Ghanaians. People should not be seen to see us as other people. We are Ghanaians.
The Minister of State...
The minister, 69, where I'm going? 69, where am I going?
No, you are contributing to Ghana, to Ghana's development, which is fine. The Minister of State,
when they were doing the leap, they didn't those pensions who are monies are there are not being looked at. How can pensioners? We are also vulnerable people. But in Ghana, when you go to Europe, when you go to Germany, when you go to Britain, when they talk about vulnerability, the pensioners are all spared. But in this jurisdiction, pensioners are not part of it.
No, but pensioners who have lived good lives and have investments and are reaping their investments, etc. I mean, yes, in terms of age and strength, you are vulnerable. But in terms of financial strength, I mean, you may not be vulnerable. Like you yourself, here you are with a lot of experience and wealth and knowledge and sharing with us.
The mess,
I'm sure that translates to the pocket as well.
My brother, the mess was not created by them. The mess were not created by the pensioners. It was created by people who have the terrible appetite to borrow everything that comes in their way. So it's not the pensioners.
Yes.
Other than who go and lobby and stand and picket.
Just to provide some information on the Financial Stability Fund, the Minister of State responsible for finance, Dr. Amin Adams, I mean, a couple of weeks ago, said that the Stability Fund was finally set to come to play with some $750 million US dollars disbursement from the Finance Ministry, and that this captures about, so this would be like 9 billion out of the 15 billion aspirational figure. So it means some work is almost, or some work is being done, and the fund will start its disbursement. I mean, that is just some information. I don't know if you have anything to say about that.
Can I provide some
so go ahead.
Yes,
so go ahead. Just go ahead. Well, so I go to Franklin when you are done.
Yes, I think the first thing is to appreciate that per our laws, it is the Bank of Ghana directly which has to support banks facing challenges through what we call the liquidity support. And that fund, that money, when the banks assess it, it is at interest. The last time that money was made available to the banks, it was at the policy rate. And so it's not even free. But regulatory activities demand that the Bank of Ghana should do that directly. Now, the difficulty with this GAT is that the GAT is coming in as if the money will have to be secured through the through Bank of Ghana through GAT, and that is strange development. Number two, the arrangement of the investment through GAT is such that you will have some common shares, then you have preference shares. And what it means is that for GAT, even if the company is making losses, they are able to secure some benefit through preference shares, because we treat preference share as though it's a hybrid instrument. The returns on preference share is assumed to be a debt instrument. So then again, they are going to be seen appointing people on the board. And I think that particular arrangement is inimical to the progress of the banks, especially when you are saying that this development in the banks is actually caused by DDEP, which was a policy framework by the government. So why will your policy framework have a toll on the bank? Then you bring a vehicle that is not friendly to the banking system. That is questionable. And the foreign banks, I'm not sure any of them will assess that stability fund, because assessing the stability fund is invitation to GAT to enter into your bank. And if a bank is not interested in that, the bank will not assess that stability fund. And the good news is that most of the foreign banks have their parent banks who will support them to capitalize. So they will not go there. So again, we are targeting our domestic banks, and which we have to look at critically. Through the financial sector cleanup or the banking sector cleanup, it was the domestic banks which had the GATT entering into their fold, and we all know what is happening with the experiences with GATT. And again, if you open the window for GATT to come in, I see a terrible corporate governance experience in the banks. Then this again provides some continuous unfairness towards the shareholders. You know, under the financial sector cleanup, there was directive against payment of dividend. So many of the banks have hold on payment of dividend. Now, under this new arrangement, after the DDEP, the banks again were told to halt payment of dividend. Now, this shareholder who should benefit from dividend, he didn't benefit from dividend from the banking sector cleanup, then he will not benefit from dividends under the effect of the DDEP, but he is called upon under financial sector cleanup to provide extra capital. Then under DDEP, he is also called again to provide extra capital. What are we doing to, especially our domestic bank? I believe this is highly unfair to them.
I see. Quite interesting there. Franklin, what are your thoughts? Why should we stop the Bank of Ghana from providing any support at all to the finance ministry, for example? Why should we agree to zero lending from the Bank of Ghana? Elsewhere, governments print money to deal with problems. Is it a good thing we have signed on to? Of course, I know the issues about responsibility and recklessly taking money from the Bank of Ghana and all of that. But to say 0%, that is quite onerous, is it not?
Well, good morning to my good friends once again. Good to see you, Prof. and Doc. Well, listen, I don't think anybody held a gun to our heads, really, when we decided that we were going to set a limit to which the central bank was going to finance the activities of the central government, right? I think we've reached the stage where we ourselves have become so indisciplined financially, fiscally, and somehow we've allowed the central bank to be used as some sort of a rubber stamping agency, right? Otherwise, why are we now accepting, because the IMF has said there should be more supervisory, should I say, sunshine on the central bank activity, and then we're actually willing to change our laws to ensure that. So in this case, the zero financing will be seen anyway. I mean, this is a true test of the central bank's independence, because now what it means is that they would, if they even give $1 to the government, they would have breached their own rules that they set. Well, perhaps not their own, because now it's been imposed, right? I think we've long held the view that when monetary policy, when government behavior is actually encouraged by the central bank, then very soon we would have a situation that essentially we are currently facing right now. Maybe there's a history to it, right? Maybe the central bank must have been sleepy during the challenges we have with the commercial banks not too long ago. But I don't think we would have served ourselves well by imposing this rather strict limiter of the central bank's role when it comes to financing government. I mean, there's nothing essentially wrong if the central bank decided that there's a limit they can't cross, maybe 3, 4, 5% financing government deficit. When it becomes a habit where continuously they are just dishing out money to the central bank and then encouraging dishing money to the central government, and the central government continues to, as it were, splurge without any corresponding productivity, then clearly you'd have the situation we currently have. So for me, yes, I understand the question as to why the central bank should somehow be seen to be supporting government initiatives. Maybe, yes, those initiatives must be productive and there must be some return, some value for money considerations whenever the central bank is lending to the central government. But where you don't see that, and I think we've now agreed that we can never be disciplined enough or the central bank cannot discipline itself enough to ensure that it does not finance government's splurge, then certainly what it is what it has become, right? So I do not really want to shed any tears for the central bank or the imposition we've had ourselves. I mean, there's been a lot of experiences. I recall, I think 2016 or 2015, when I visited the Central Bank of England. I met with the Director of Development of the English Bank, Central Bank, and I remember his parting words really. He said, look, whatever you do, never allow your central government to dictate the pace for the central bank. Because when that happens, you'd have lost all sense of, independence, and then you'd have set your government on the path, or you'd have set your people on the path of, some sort of, forgotten the word he used, but essentially suggesting that would have been in the wilderness. And so wilderness we have been right now, as you see what is currently happening to us. So I don't think this is a colonial imposition. This is we saying that we have become so indisciplined that we now accept that we would no longer give even $1 to the central government. I don't think that is sensible, but under the circumstances, why not? Look, haven't we now we are now currently looking at reviewing some of the government flagship projects. But this has been on the table all this while. It should have been part and parcel of the design process when these projects were envisioned, right? You shouldn't take the IMF to come and tell us that, well, look, you need to target your certain policies properly. It should have been part and parcel of the whole arrangement from day one. So if that is what would take the central bank to be fiscally responsible, well, so be it.
I see. Honorable Abanu is still with me in the studio here. The election year is next year, and these strictures or these targets and limitations on our spending, etc., we've agreed to be imposed upon us by the IMF, will surely have implications for elections. And historically, we've not done so well in terms of deficit, etc., in election years, apart from 2004, as I did state earlier. What does this mean to us? What does it mean to the political structure? Are we going to have a lean election, or are we going to breach the terms of the targets or the terms of the IMF? What really would that be, and what will it mean for us in the program?
Yeah, thank you very much. During election years,
everything is on break.
It's not that everything is on break. you realize that the demand for one development here or the other, as a condition for votes, becomes higher. And any political party in government, with the aim of retaining itself in government, some way, somehow becomes very vulnerable and would want to satisfy these demands in order to court the support and votes of those people. So you are on a campaign trail, they say, oh, if you don't construct this road for us, please don't come here, we won't vote for you.
Even if there's no money, we must find money and do it.
And a government that is desirous of, or a political party in government that is desirous of retaining power, would want to find money one way or the other to do that, or probably gets a contractor who is ready to do it, and that debt is deferred, but definitely we have to pay, right? These pressures is what leads to
the
deficits, huge deficits during election years. But I think that this is the 17th time we have gone to IMF, and it appears to me that every time that we visit IMF, the collateral effect is that we visit further hardship on our people. The time has come where we have to be financially and fiscally disciplined in the way we spend. Right? I think strongly that in some of the SOEs, they could have done much, much, much better than they are doing. But what is the problem we see? We have sometimes square pegs in round holes, right? Not because those people are competent enough, but because those people are loyal to party. We can't run away from that. When we start dealing with these realities, that is when we can let these SOEs do well right? If it is not doing well today, divest it or given to a private person, immediately it has a turnaround. Why? So government interference in those places, we must check it. Certain appointments that are not necessary, we must check it, right? Beyond that, the whole bureaucracy itself, we must also check it, okay? Because there are a lot of leakages and loopholes in various ministries, departments, agencies, and all that.
How about people who think that the IMF deal, for example, and the arrangements you've had with them will lessen the burden on government in terms of some of the impositions on the people? So, for example, the IMF is talking about tariff adjustments quarterly. And so when the adjustments happen, of course, people will blame government, but people will know that it's because of the IMF. And so government takes a bit of a break from that bashing. So it's good for government, even though it's painful to the people. So we bring the matters from the difficulties or the debt at the energy sector level, at the energy sector, a bit, we drive it down. So we bring you bring it to, closer to cost recovery, full cost recovery.
Let's be realistic here. My grandfather, who is in the village and who has never heard of IMF, all he knows is that things have been increased.
But you explained to her that it's IMF that has forced us to do it.
No. Okay, I can assure you that it's only a few who would understand these things. But in any case, who goes up? It's us. And I admit, I acknowledge that the COVID and
the
Ukraine war is part of it. But I am always bold enough to state that part of it is also
internal.
Yes, internal.
Very well. Let me conclude with this, that the IMF has said that the free SHS, which is a major issue, of course, the IMF is made room for social protection and leave, etc. I come to you on this closing remark, Dr. Twahine. The IMF says that the free SHS has been poorly targeted. What do you think can be done to properly target it so that the amount of money government is devoting to this, government can redirect that to somewhere else? You have a few seconds to address this, please.
Thank you very much. I think beginning of the free SHS, people said it that there are too many wealthy people in this country. And I remember the finance minister saying that he could pay his children's fee at Chachimota, if I'm wrong.
That's true.
But you see, if you make it a wholesale because you want to win politics, if you want to win power, and you don't do the calculations very well, and begin to do a proper targeting, you end up by saying the IMF telling you that poor targeting. I believe, as Franklin said, do we need the IMF to come and tell us this program? This program, right from its onset, some Ghanaians, well-meaning Ghanaians, came out with figures that what we are doing, we are going to shoot ourselves in the neck. And today we have shot ourselves in the neck because we are not getting quality education. I mean, look at the school years. Somebody goes to in January, 3 weeks, he come home, stay home in June. Has any of these people, has it been those who went to Prempeh College in Fansepen? In those days, could you go to school for only 3 weeks and come back home? But you see, when we said it, they said, Franklin said it, they say, hey, Frankie doesn't like it. But Dr. Gazi said, he doesn't like it. Once we don't accept our problems and want to solve it scientifically when with data, we will continue to come back every now and then on this issue. That's my comment.
Very well. Quickly, 1 second.
A quick intervention. You know what?
1 second, yes.
This happened because Ghanaians are like that. When they introduced Get Fund, when we were on campus, they said they were looking for needy but brilliant students.
Everybody went.
Everybody went.
I see. So this everybody will go. All right. So everybody has gone. Guys, thanks so much. I wish we could have done more. But that's how we conclude today's edition of the program. Thanks to my Franklin Kujo, President of Money Africa, Professor John Gachi, Dean of the School of Business, University of Cape Coast, my alma mater, Dr. Richmond Etiwahene, Banking and Finance Consultant, Alex Aban, former MP and also lecturer, banking law. My name is Selam Adunu. Catch you same time next week for another exciting edition of The Big Issue.
God bless her homeland.